When House Speaker Pelosi announced the impeachment managers for the Senate trial, she made it clear that the managers' legal experience was a crucial factor in her decision making. Let's listen.
As you can see from these descriptions, the emphasis is on litigators. The emphasis is on comfort level in the courtroom. The decision to come down in favor of litigators is necessitated by the clear evidence that we should have witnesses and we should have documentation, and we have to make the strongest prosecution, not only of our very strong case, but of all the information that has come forth since.
4 of those 7 impeachment managers have experience in the courtroom. Adam Schiff was a federal prosecutor in Los Angeles for 6 years. Hakeem Jeffries was a litigator at a private practice. Jason Crow has experience as a private litigator. And Sylvia Garcia was a presiding judge of the Houston municipal system. For more on this, Natalie Brand joins us from Capitol Hill. Hi, Natalie. What does this selection of impeachment managers say about how Pelosi wants this case presented in the Senate?
Well, you heard from the speaker herself that she wants that comfort level in the courtroom, heavy emphasis on prosecutorial experience. But what's also notable is the diversity among the 7 managers, geographic diversity, diversity in terms of length of time that these members have served in Congress, and a wide range of experience. So you noted the courtroom experience or former litigators of the group. That includes Intelligence Chair Adam Schiff, who is named the lead manager. He not only has that experience as a former federal prosecutor from the U.S. Attorney's Office in Los Angeles, but as you know, he's been leading the impeachment proceedings in the House as a key member, played such a prominent role during all of the hearings and proceedings leading up to this point. The other former litigators, Jeffries, who's also a member of Democratic leadership, and Jason Crow, a freshman from Colorado, who's also a former Army Ranger turned litigator. And what's notable, he's part of the freshman group of members with national security experience from swing districts who announced their support for impeachment after the Ukraine revelations surfaced, came to light. And then we also have freshman Congresswoman Garcia from Texas, as you noted. She's a former director and presiding judge from the Houston municipal court system. We also have members of this group who have long histories, notable histories in Congress, and that includes Judiciary Chair Jerry Nadler, and then also Zoe Lofgren of California, who is the only member to have participated in the past 3 impeachment proceedings. She was a staffer on House Judiciary during Nixon. So she's offered a really unique perspective here. And we have Orlando Congresswoman Val Demings, a former police chief. So she obviously offers a different type of experience when it comes to law enforcement and the law.
And of course, this trial will be a Senate trial, not a criminal trial. So can you remind us of the key differences?
Well, I think the first big difference here is the senators themselves have the power to really shape this process and set the rules. It will take a simple majority to vote for a resolution laying the ground rules for the Senate trial. And from all the signals, the messaging that we've heard from key Republican senators, it will look a lot like what we saw during the Clinton impeachment trial. And that means each side will get about 24 hours to present their case. This is something that could go weeks, could be 6 days a week. So senators, although they will be sworn in as jurors who obviously are supposed to serve an impartial role, I think you can't separate the politics from this trial. The senators obviously have a lot of opinions. The Republicans have largely supported the president throughout this process. So while this is a trial and the senators will soon be sworn in to serve as jurors, it's a lot different than a criminal courtroom where you have a randomized group of people who are supposed to be uninformed about the case they're about to hear.
Yeah, and Mitch McConnell went as far as saying, I am not impartial. So that's setting the groundwork for that right away. All right. Now, we do know, Natalie, that Chief Justice John Roberts will preside over the trial. Can you explain what exactly his role will be?
Well, largely that's really up to how he defines his role, and that's what a lot of folks and court watchers, Supreme Court watchers, will be interested to see. Given that he has a more cautious approach and he's known for trying to really uphold that cautious approach, one law professor I spoke to recently says he expects the Chief Justice to conduct this in an honorable, impartial way, lending credit to his court. He's known, again, for this type of approach, saying during his confirmation hearing that it's his job to call balls and strikes and not to pitch or bat. But are there instances when he might be able to insert himself or choose to? We'll have to see. According to the Senate rules, he can rule on different questions of evidence or various questions that are brought forward throughout this process, but then he can also defer to the senators who would then have a simple majority vote on this process. And the rules also leave it up to the senators themselves to compel witnesses. So whether or not he somehow becomes a part of that process, we'll have to see whether he makes specific rulings on evidence or witnesses. But again, if you give a careful read of the rules, it does leave a lot of power up to the senators. But unlike the threshold to convict, the threshold to create rules or compel witnesses is just that simple majority. So as we've been talking about, there are a handful of moderate Republicans or Republicans up for re-election who will play a critical role in this entire process.
All right, Natalie Brand on Capitol Hill. Thank you.